Let's talk about public hearings under the State Administrative Procedure Act, the APA. As you'll recall, the rulemaking entities of the executive branch of California state government are required to comply with California's Administrative Procedure Act, the APA, found in the Government Code. And as a general rule, these state agencies and departments must conduct a public hearing on any proposed regulation if they're requested to do so by any member of the public. Pursuant to Government Code Section 11346.8, if a public hearing is held, both oral and written statements, arguments, or contentions must be permitted. However, the agency may impose reasonable time limitations on any oral presentations at these public hearings. This section of the Government Code also specifies that a public hearing must be held if no later than 15 days prior to the close of the written comment period, an interested person or his or her duly authorized representative submits in writing to the state agency a request to hold a public hearing. Now, if such a request is made by a member of the public, then that state agency or department has to provide notice of the time, date, and place of the public hearing. And they do so by mailing a written notice to every person who has filed a request to receive such notices from the state agency. State law also requires state agencies to consider all relevant matters presented to it before adopting, amending, or repealing any regulation. The state agency has the authority at these hearings to administer oaths or affirmations by those who appear before them, and an agency may continue or even postpone a hearing to a time and place as it determines. However, if a hearing is continued or it's postponed, then the agency is required to provide notice to the public when the hearing will be resumed or when it's being rescheduled. The other thing under this section of the Government Code is if a comment made at a public hearing raises a new issue concerning a proposed regulation and a member of the public requests additional time to respond to this new issue before the state agency takes any final action, then the legislature intends that rulemaking agencies actually consider granting the request for additional time if under those circumstances, granting the request is practical and it doesn't unduly delay the proposed regulatory action. So how have California courts viewed the public hearing requirements under the APA? In the 2013 California Appellate Court case of Sims versus Department of Corrections and Rehabilitation, the appellate court said that a hearing on a proposed regulation is on the merits and meaningful as required by the APA only if the interested public has timely received all available information that's relevant to the proposed regulation, an accurate and as complete as reasonably possible information, regardless of whether large numbers of interested people were provided an opportunity to be heard. In a 1982 California Court of Appeal case in Stauffer Chemical Company versus California State Air Resources Board, the appellate court said that although the right to a hearing in a quasi-legislative matter is not constitutionally compelled, both the mandate of the APA and the principles of fairness require a public hearing before a state agency may render its quasi-legislative decision. The purpose of the public hearing, in part, is to provide an evidentiary record permitting meaningful judicial review. And the hearing need not be trial-like in nature, nor are there absolute rights to present rebuttal evidence or any other requirements that the agency prepare findings in support of its quasi-legislative decision, the court said. One other Court of Appeal case from 2015, AIDS Healthcare Foundation versus the State Department of Healthcare Services, the court said that where statutes prescribe hearing procedures for various individual state agency proceedings, those provisions prevail over the more general provisions contained in the APA. So these public hearings under the APA are definitely an important component of the state rulemaking process. And interested parties should utilize these public hearings to present some of their key arguments and their advocacy materials to the state agency as they consider promulgating or adopting a regulation in compliance with the APA.